The second part of judicial control of administrative discretion is the failure to exercise discretion. It exactly means where the authority is given discretionary power, it is expected to exercise it by applying its mind to the facts and circumstances of the case. If the authority does not do so, the authority will be deemed to have failed to exercise its discretion, and failure to exercise discretions are of non-application of mind, acting under dictation, imposing fetters on the very exercise of discretion, then acting mechanically, then abdication of functions. So, regarding the first one, non-application of mind, it means where an authority is given discretionary power, it is required to exercise it by applying its mind to the facts and circumstances of the case in hand. If he does not do so, it will be deemed to have failed to exercise its discretion, and its action or decisions will be bad, as it was held in the leading case Narendra Kumar versus Union of India in 1990 by the Supreme Court. And regarding the second one, to failure to exercise discretion is acting under dictation. So, where the authority exercises its discretionary power under the instruction or dictation from superior authority, it is taken as non-exercise of power by the authority, and its decision or actions is bad. And in that connection, we will discuss a leading case in Pratappur Company Limited versus Ken, Commissioner of Bihar in 1969. Supreme Court expressed that the commissioner exercised his power under the dictation of the chief minister. The court held that the power was exercisable by the Kane commissioner, and it was not proper for him to abdicate his responsibility in favor of the state government or the chief minister. Consequently, the order of the Ken commissioner was quashed. However, it is to be noted that if the authority entrusted with the power to take assistance of advice of some subordinate authorities before exercising its power, but it takes the final decision itself, applying its mind, the action of the authority will not be bad. And in another case, that is imposing fetters on exercise of discretionary power, so also falls under failure to exercise discretion. So it means if the authority imposes fetters on its discretion by announcing the rules of policy to be applied by its rigidly to all cases coming before it for decision. Its action or decision will be VAT, and in the very leading case, Shriram Sugar Industries versus State of Andhra Pradesh, it was clear the policy decision of the government was upheld. The government was given discretion to exempt any sugar factory from payment of tax for 3 years. The government adopted a policy to grant the exemption only in favor of the cooperative sector. The court upheld the action of the government. And another factor of failure to exercise discretion is acting mechanically. And it means if the authority entrusted with the discretionary power passes an order mechanically without applying his mind to the facts and circumstances of the case, the authority is taken to have failed to exercise his discretion, and its actions or orders will be bad as it was held in the leading case. Assistant Collector of State Duty versus Prag Das Agarwal in 1981 by the Supreme Court. So, the last factor, as we would like to discuss under the head failure to exercise discretion, is abdication of functions, which means if the discretionary power is given to an authority but the authority leaves it to be exercised by the subordinates without acting itself. In such condition, the order passed by the subordinate in the exercise of the said power will be considered as bad. It is taken as abdication of functions. So, in the leading case, Manik Chand versus State in 1973, the Gujarat High Court expressed the relevant statute. The corporation was to consider the scheme of nationalization of certain bus routes, but the scheme of nationalization of certain bus routes was published by the manager of the State Road Transport Corporation, and the corporation did not consider this scheme, and it was taken as abdication of function, and the Gujarat High Court held that it is bad and it is a part of failure to exercise discretion on the part of the administrative authorities. So, these are the various mechanisms provided regarding judicial control of administrative discretion, and which are categorized as abuse of discretion and failure to exercise discretion. So, under abuse of discretion, first we discuss regarding use for improper purposes, and the second one regarding malafide or bad faith, and the third one regarding irrelevant consideration, and the fourth one leaving out relevant consideration, and the sixth one, that is relating to unreasonableness in exercise of administrative discretion, and the seventh one, that is relating to colorable exercise of the discretionary power, and the next one that is regarding non-compliance with procedural requirements, and the last one relating to exceeding jurisdiction, the very act of the administrative authorities exercise of discretionary power. And regarding this second category, that is failure to exercise discretion, we discussed on the ground of non-application of mind by the discretionary authority and acting under dictation of some other authority or the government, or imposing fetters on the exercise of discretionary powers, and also when it acts mechanically and when it abdicated its own functions. And these are the different judicial mechanisms to control administrative discretion, as we found under the very head judicial control of administrative discretion.